Begin with a household tablet rather than a battlefield. A Roman hand writes a list in wax: tools, jars, animals, debts, fields, and people. One entry belongs to a human being, yet the law does not place that person among heirs, tenants, debtors, or citizens. It places that person among property. That is where the Roman law of slavery begins, with one of the hardest acts any legal order can perform. A speaking, working, remembering human being is entered into another person's estate. The questions in this episode are blunt because the law itself is blunt. What did Rome mean when it divided persons into free and enslaved? How could jurists say that freedom was natural while accepting slavery as lawful? How did a person treated as property work, trade, form attachments, give evidence, suffer punishment, and sometimes become free? And what kind of freedom did manumission create when the former master could remain as patron? Roman jurists opened the law of persons with a basic division. People were either free or enslaved, and everything else followed from that line. A free person could stand inside family law, marriage, inheritance, litigation, and civic standing in his or her own right. An enslaved person stood under master. The law could see that person, use that person, punish that person, value that person, and sometimes release that person. It did not ordinarily allow civil rights to rest there for that person's own benefit. The source caution should be clear at the start. The best preserved legal shape comes from classical and later juristic writing, from textbook exposition, and from imperial rules that preserve legal categories more fully than the voices of enslaved people. We can see the machinery with unusual precision. We cannot pretend that the machinery gives us the whole interior life of the people caught inside it. The record is formal, elite, and often cold. Its value is that it shows how the institution worked. Its limit is that much of the human experience remains outside the legal wording. Jurists themselves give us the central contradiction. Freedom could be described as the natural condition of human beings. Slavery could still be accepted as part of the ius gentium, the law of peoples, explained through war, capture, and the practices shared among states. That is not a moral defense. It is a legal accommodation. Roman law could acknowledge a natural idea of liberty while building rules for the owning of human beings. The contradiction was not removed, it was administered. In private law, the enslaved person could be treated as a res, a thing, an item of property. The word matters because it shows the legal placement. A field, a jar, an animal, and an enslaved person could all stand within another person's property. Yet the category never behaved like inert property. The person named on the tablet could speak, remember, learn, obey, resist, purchase, injure, love, testify, flee, save money, and hope for freedom. Roman law never solved the problem that human property was still human. It built procedures around that problem and used them for centuries. The roads into slavery show how wide the institution became. War and capture were central, above all as Roman conquest spread across Italy and the Mediterranean. Captives could be sold, divided, transporting, and placed into households, farms, mines, workshops, or markets. A child born to an enslaved mother was normally enslaved, for the mother's status determined the child's. Enslavement could come as punishment, especially for those of lower status condemned to the mines, the gladiatorial schools, or other harsh penalties. Market sale, piracy, exposure, and extreme vulnerability around household support also fed the institution at different times and places. Roman slavery was not one road into one kind of work. It was a legal status into which many roads could lead. That variety matters because the legal category compressed very different lives into one word. A prisoner taken in war, a child born in a master's household, a skilled Greek teacher sold after conquest, a man condemned to the mines, and a domestic attendant trained from youth could all be called slave in law. Their daily conditions could differ sharply, their chances of manumission could differ sharply, their economic value could differ sharply. The law could record all of them under ownership. That compression is one reason the legal sources can feel so cold. They make very different human histories pass through the same line of status. Once inside that status, the legal effect was severe. An enslaved person did not ordinarily own property in the full civil sense. What came into the slave's hands came into the master's estate. The enslaved person did not ordinarily sue or contract for personal civil benefit. Lawful Roman marriage was not available because lawful marriage required contubernium, the legal capacity to marry in Roman civil law. Slave status did not merely say that a person owed labor. It said that the person stood in law through someone else's ownership. Even so, Roman society needed enslaved people to do far more than stand still as assets. They worked across the household, the countryside, the workshop, the office, the town, and the state. Some were field laborers under hard supervision, some kept domestic spaces running, some worked as artisans, teachers, accountants, physicians, scribes, agents, wet nurses, miners, entertainers, and estate managers. Public and municipal slaves could perform administrative and technical work. Imperial slaves and freed people could stand near the machinery of power. The single status of slavery covered radically different kinds of work. The job titles preserved in Roman sources help us see the point without softening it. Some enslaved people handled stores and cash, accounts, correspondence, transport, or business instructions. Others worked in places where exhaustion and death were expected parts of the penalty. The law did not treat skilled work as a rescue from status. A bookkeeper could still be owned. A physician could still be owned. A teacher could still be owned. Administrative usefulness could bring proximity to power, and proximity was not liberty. It was another way for ownership to use a human capacity. That range prevents two mistakes at once. It prevents the polished mistake, in which a skilled or trusted enslaved person is imagined as half-free because responsibility was given. It prevents also the narrow mistake, in which Roman slavery is imagined only as one visible scene of chains and manual toil. The institution could be brutal in the field and managerial in the counting room. It could place a person at a desk, in a kitchen, in a quarry, in a schoolroom, at a dock, or beside a magistrate's records. Variety in work did not change the legal status. Skill could raise value and responsibility without removing ownership. Peculium is the device that shows this most clearly. A master could allow an enslaved person to hold and manage a fund. The fund might contain money, goods, tools, claims, land, business stock, or in some cases other enslaved people. In daily life it could look like working capital. It could let a person keep accounts, run a shop, make purchases, settle obligations, or build value toward a possible release. But in law the peculium remained the master's property. The enslaved person managed it and did not own it against the master. That is why peculium matters so much. It created room without granting independence. It allowed action while preserving control. The master could profit from skill, initiative, and discipline while keeping legal title to everything the enslaved person handled. The enslaved person might save within the fund, bargain around it, or hope it would help buy freedom for self, partner, or children. Even then, the decisive fact remained. The room existed by permission and inside another person's estate. The peculium could even reproduce the institution inside itself. Such a fund could include not only money or goods, but in some cases, other enslaved people. That detail is uncomfortable and important. A person without civil ownership could manage property that included another person without civil ownership. Roman law could build layers of control below the master's ownership while keeping all final title above them. The device made economic life more flexible, and its flexibility worked for the institution, not against it. Commerce pushed the law further still. If masters wanted enslaved people to trade, manage, order, ship, borrow, or negotiate, outsiders needed some way to deal with that activity. Otherwise, a society using enslaved agents would be hard to trust in business. The praetor, the magistrate whose edict shaped practical remedies, gave creditors actions that connected some servile transactions back to the master. If an enslaved person acted with authority, acted through a peculium, acted within a business role, or enriched the master's estate, the creditor could sometimes pursue the master within defined limits. The point is precise. Roman law was not making the enslaved person an ordinary free contracting party. It was making slave agency usable. The enslaved person's act could matter, the enslaved person's knowledge could matter, the enslaved person's management could matter. But the civil consequences normally moved through the master, the peculium, or the master's estate. Rome wanted the advantages of human initiative while preserving the rule that the legal value of that initiative belonged elsewhere. Household relationships reveal the same tension. Ordinary enslaved people did not have lawful Roman marriage, they lacked connubium, and their unions did not create marriage in the civil sense. Yet enslaved people formed lasting relationships, raised children, built household bonds, and lived with attachments that Roman sources could notice under the name Contubernium. That word should not be inflated. Contubernium was not legal marriage. It gave no standing like a lawful union between free persons. It should not be flattened into nothing either. The law sometimes noticed blood and household ties formed in slavery, above all after manumission, when those ties could matter at the edges of later marriage rules or family consequences. This leaves a careful statement. Roman law refused enslaved relationships the ordinary legal security of marriage. It did not always refuse to see that the relationships existed. It recognized them when another legal question forced the recognition. Again, the person appeared when the legal order needed the person, and was pushed back under the status of property. The coercive center of the institution appears most sharply in punishment and evidence. If an enslaved person committed a wrong, Noxal liability could allow the master to answer by surrendering the enslaved person to the injured party. The body and status of the enslaved person became part of the master's legal answer to wrongdoing. That was not a free defendant answering in court through ordinary civil standing. It was a property owner's answer to damage created by a dependent person or asset. Evidence shows the same violence in another form. Slave testimony was tied to coercion. Roman procedure commonly treated testimony from enslaved people as testimony extracted under torture. Ancient writers could recognize the danger and instability of such evidence, and the practice remained because the institution itself rested on compulsion. The law wanted speech from the enslaved person, and it wanted that speech under force. Even truth became entangled with ownership and pain. Nothing shows that deeper coercion more starkly than the Senatus Consultum Silanianum. Under this senatorial decree, when a master had been murdered, the slaves of the household could be interrogated and put to death, because the law assumed they had a duty to protect the master's life. The premise was not simple individual guilt. It was household discipline backed by collective terror. Tacitus preserves the Nero-era case after the murder of Pedanius Secundus, when hundreds in the household faced execution despite public protest and despite the plain innocence of many. The example matters because it strips away every softening phrase. Roman law could be technically refined and still rest on organized fear. Later imperial law did restrict some forms of brutality. Masters were not left forever with the same unchecked language. Measures could punish unjustified killing, answer extreme cruelty, or protect an enslaved person forced into prostitution. Justinianic law later reduced the language of master power toward reasonable chastisement rather than unlimited violence. These changes were real, and they should be stated. They should not be mistaken for a movement toward abolition. Roman law limited some abuses while leaving slavery itself intact. The institution was being adjusted, not rejected. Manumission shows the other half of the legal order. The word means release from the hand, and it marks the act by which a master frees an enslaved person. Roman slavery was harsh, and it was not always imagined as permanently closed. A person might be freed by vindicta, a formal process before a magistrate, by census through enrollment with the master's approval, by will, by a trust laid upon an heir, by declaration in church in the later empire, by informal release before friends or by letter, or in special cases of reward. Each road had its own form and its own risk. Freedom could be direct, conditional, delayed, or dependent on someone else's compliance. Testamentary manumission deserves particular attention because it turns a household death into several legal thresholds at once. Property passes, heirs arrive, debts settle, and one or more enslaved people may step into liberty because the master's final act has ordered it. The 12 tables already knew conditional manumission by will. A person might become free only after paying a sum to the heir or satisfying a condition. The detail is important, for it shows how early freedom could be tied to payment, inheritance, and the continuing interests of the master's household. The popularity of manumission brought state control. Augustus did not leave release to private feeling. The Lex Fufica Caninia limited how many enslaved people could be freed by will. The Lex Alia Sentia regulated age and status, and could place some freed people in damaged categories. The Lex Iunia, connected with informal manumission, helped define the Junian Latins, people released from slavery without full citizen standing. A Junian Latin might be protected in freedom during life, yet lack full testamentary capacity, with property reverting to the patron at death. These categories show that Rome valued manumission and feared it in the same breath. Private release from slavery could alter the citizen body, so the state intervened in the terms on which release counted. Formal manumission could lead to Roman citizenship, and that feature made Roman practice famous in the ancient world. King Philip V of Macedon could point to Rome's habit of admitting former slaves into citizenship as a source of strength, even if he overstated what freed people could do. A freed person did not become freeborn. Major public office and military service could remain closed. The legal stain of servile origin did not simply evaporate. Yet the children of freed people were freeborn, and that changed the future of a family. Manumission could move a household across generations, even when the first generation still carried visible limits. Later imperial law simplified parts of this landscape. Justinian removed some of the intermediate categories, the Junian Latins and the Deditici among them, and widened the path by which manumission led to citizenship. That development matters, and it belongs to a later stage. It should not be projected backward, as though the road from slavery to citizenship had always been clear. The history is a sequence of openings, controls, and reclassifications, not one steady ascent. Even freedom did not erase dependence. The freed person, the libertinus or libertina, entered liberty in a changed legal condition, and the patron remained in view. The former master became patron or patroness. Services, called operi, could still be owed. Respect, called obsequium, carried legal weight as well as social expectation. Gifts or support might be agreed. A freed person could face limits on discrediting litigation against the patron, and patronal interests could still reach into succession. Names could carry the change in public form. A freed person often took the former owner's praenomen and nomen, the personal and family names of the patron, while keeping the old slave name as a cognomen. That naming pattern advertised entrance and memory together. It said that the person now stood in civic life, and that the path into that life ran through a patron's household. Inscriptions and tombs make this visible. Freed people wrote themselves, their spouses, their children, their trades, and their benefactions into stone, often with a pride that elite writers could mock but could not erase. This is where Roman law shows its preference for continuity over rupture. Manumission ended ownership. It did not require the memory of ownership to disappear. A freed person might gain property, marry lawfully, enter business, vote in certain settings, join civic life, and see children born free. Those gains mattered. Some freed people became wealthy and publicly visible. Their tombs, names, businesses, and benefactions show real movement. Yet the law still marked the difference between freeborn and freed. It carried the old household relationship forward in altered form. So the Roman law of slavery is not best understood as a failure to perceive humanity. The harder truth is that it did perceive humanity and still classified the human being as property. It noticed skill when a master needed profit. It noticed speech when a court needed evidence. It noticed attachment when later family rules needed blood. It noticed aspiration when peculium or a will pointed toward manumission. It noticed suffering enough, at times, to restrain some extreme violence. Then it placed all of that back inside a legal order built on ownership, coercion, and hierarchy. That is why the tablet remains the right image. One line in wax holds two truths at once. The law calls the person property. The world built by that law requires the property to live and act as a person. Roman jurisprudence did not resolve that contradiction. It made it durable. It made it ordinary. It made it useful in the household, in business, in punishment, in inheritance, and even in the controlled passage from slavery into freedom. That is the hardest thing to look at directly, and it is the thing the law itself never let go.